Um, all right, so next we have a speech by John Sallet, who, like everyone else, needs no introduction to the audience here. So, as before, I won't give one. So John is gonna talk. We'll then have a short break, and then we'll have our last panel of the day. It's even possible we could even start our last panel a couple of minutes early. Wouldn't that be amazing? But without any further ado, John Sallet.
Thank you very much, Stuart. I appreciate the chance to speak here at this program today. It's important that we look forward to the year 2020. I'm going to look forward to a slightly shorter time span, but hopefully one of interest as well. You remember the movie Annie Hall, right, where Woody Allen is in a home in Los Angeles, and he's walking down the hall, and you see Jeff Goldblum on the telephone, who's saying urgently, "I forgot my mantra." At the FCC, let me assure you that the commission staff always remembers the chairman's mantra. It's competition, competition, competition. The chairman took office just about a year ago, and in that year, competition has been the continuing theme. To take just two for many examples, competition theory was the basis for the commission's mobile spectrum holdings order. It supports orders that impact the way that television stations can and cannot collaborate with each other. If a mantra can also be a mem, if that's the way it's pronounced, which is, I understand, the smallest possible unit of an idea, then competition is mem and mantra of the commission's work under Chairman Wheeler. Since Labor Day, Chairman Wheeler has given 4 speeches about competition, laying out what he calls the agenda for broadband competition, the ABCs of competition policy. First, he described the challenge of competition in fixed broadband, explaining that 25 megs down, 3 megs up bandwidth is table stakes for the 21st century. In a speech at the Tech Incubator 1776, he focused on the competition challenge that exists when, in a time of heavier and heavier video use, 75% of American homes have no choice or only one choice for that kind of high-speed bandwidth. Second, he talked about mobile. The chairman praised existing competition and new marketplace initiatives, but he also asked a fundamental question. Should mobile broadband be subject to the kinds of open internet rules that ensure, for example, that a downstream network cannot artificially disadvantage an upstream company with which it is also competing? That question remains on the table. Thirdly, he talked about reducing barriers for competitive broadband providers, because after all, the best cure for limited competition is more competition. The chairman urged local governmental officials to take steps to incent broadband deployment. He explained then why the commission would vote, in fact, at its open meeting this morning, did vote unanimously on federal policies that govern the siting of wireless facilities in order to speed the deployment of wireless networks. Finally, he turned to last-mile competition as it affects business customers, especially small and medium-sized businesses whose demand for bandwidth in a single location may not justify the building of new facilities to their space. With the approval of Howard Shalansky's office in OMB, the Commission is now collecting data on the market for so-called special access, dedicated high-capacity lines to businesses. Those data will allow the Commission to identify where there is market power. Just as importantly, the Commission can identify where competition exists and where, therefore, regulation should be abolished. A core conclusion articulated in the 1776 speech is this. Communications policy has always agreed on one important concept. The exercise of uncontrolled last-mile power is not in the public interest. This has not changed as a result of new technology. I've labeled this talk C3, or C cubed, I guess, I should say, to reflect 3 dimensions of the chairman's agenda for broadband competition. First, how the Commission might be able to incent more competition. Secondly, how it can protect competition that exists today. Thirdly, to identify the scope and contours of competition as administered under the FCC's public interest test. Let's begin by asking what the Commission can do to incent competition. We need to start, I think, by understanding that competition and what we want to go with it, innovation, is not limited to technology. Think about Apple's iPhone launch in 2007. That was a market-changing event, but it wasn't about technology only. In some real respects, the magic of the original iPhone was that it was a result of innovation in product design and business models as well. The same is true of the first Apple App Store in 2008. It was important, but to many people, the surprising innovation was the creation of a marketplace for mobile apps alongside the apps themselves. Business model innovation is particularly important in times of dynamic competition as firms experiment with ways to provide differentiated forms of value. I want to take a few minutes today to talk about one market in particular, and that's the marketplace for video programming. Tremendous innovation bringing competition to facilities-based cable services has been introduced by over-the-top video providers. Netflix has as many as 36 million subscribers in the United States today. Video traffic has become the majority of the downstream internet traffic during peak periods. Choices of on-demand services are flourishing: Amazon, Apple, Hulu, YouTube, to name a few. Just this week, just in the last couple of days, both HBO and CBS have announced new streaming services separate from cable subscriptions. The New York Times this morning called these developments a, quote, watershed moment for web-delivered television. And that's not all. There are additional forms of business model innovation in the offing. Dish has publicly stated its intention to expand into streaming TV video in a different way by providing packages of channels that look a lot like traditional video programming. Sony as well has confirmed its plans to deliver more than 20 linear networks over the top. This is business model innovation. Of course, the Commission doesn't root for one business model over another, but it does, and it should, I think, look to see if any of its rules should be updated to facilitate the innovation that can occur in the marketplace. Which brings us to the rather technical question of the definition of an MVPD. That's short for multi-channel video programming distributor. It's not the name of an 80s rock song. Congress told us that a cable system must be facilities-based, but an MVPD need not be a cable system. These are two very different terms as created by the Communications Act. So a series of questions arise. Start with this. Could the definition of MVPD be technology neutral so that OTTs that choose to offer multiple streams of pre-scheduled video programming would qualify for the programming's rights and responsibilities created by the Communications Act? Let me emphasize that such a definition would not include on-demand video providers like Netflix, Hulu, Amazon, or Apple. Why might this be important? Well, think for a moment about the critical inputs to a business that wants to use the internet to deliver linear channels, pre-scheduled channels, of video programming in competition with traditional cable systems. The OTT must be able to reach its customers over broadband transmission. That's a question for the open internet proceeding. Such a business must also obtain video programming. As a general matter, that's resolved via private negotiations in the marketplace. But Congress in Title VI of the Communications Act recognized that cable companies that own programming might refuse to supply that programming to competitors. The theory was that when cable companies own content, they may raise artificial barriers to entry by refusing to let their video competitors have access to the programming they own. In doing so, they could harm satellite providers. That was the original genesis of the problem. So we ask, would OTTs using broadband transmission face the same threat today? Would providing to some OTs the programming rights of MVPDs spur competition by eliminating this risk? Would the public benefit if those same OTTs and broadcast stations also had the congressionally congressionally granted right and duty to negotiate in good faith the retransmission of television signals. The prospect here is not just that consumers would have more individual choices, although that is plenty a good thing in and of itself. But as in other technology sectors, the prospect is that they'd be able to mix and match those choices in order to create individualized packages. Think broadband, various slices of video programming, different forms of devices, both fixed and mobile, putting together packages of their own making. The chairman recently confirmed that the commission staff is looking anew at this issue, first raised in the complaint filed in 2012 by Sky Angel. That is, to give the lawyer's statement of the question, whether it should define an online video provider that delivers multiple streams of linear programming as an MVPD. We've put that specific complaint to one side to consider more generally whether this definition is technology neutral, so that the statutory rights to programming would be available without regard to the nature of transmission technology. And also to explain and to consider that the fact that it would be narrow, applicable, as I said before, only to those companies that make the choice to engage in this business model of delivering multiple streams of pre-scheduled programming. At recent meetings with the commission, Aereo, a company that's been in the news quite a bit this year, said that this kind of approach, if adopted by the commission, would, and I quote, create regulatory parity, increase investment and competition in the video programming market, and provide consumers with attractive competitive alternatives to existing MVPD services. Such action would not regulate the internet. Indeed, the whole point of the inquiry is to apply the act on a technology-neutral basis so that it would make no difference whether the internet did or did not serve as the means of transmission. To aid the commission's analysis, the Media Bureau issued in March of 2012 a public notice to obtain additional comment on these difficult issues. It is, of course, the Media Bureau, led by Bill Lake, that is the commission's expert on video competition. And if I could just offer a brief aside, the first job at a law firm that John knows well that I had helping with competition law was when I was a summer associate working for Bill Lake, one might say in the last century. And you know, I've known him for a long time. I've known why his leadership on this and other kinds of issues is so critical to the commission. But let me return to the topic. So what are the kinds of questions that the commission is considering? Should we prefer technology neutral over technology specific applications of the law? Would business model innovation in the delivery of video packages like these serve the public interest by providing more competitive choices for consumers and the benefits that competition provides? How might this help over-the-air television? Would television stations and programmers, studios, have more potential customers, thus introducing greater competition in the B2B market for program distribution? There's also the important question of whether this action would help boost horizontal competition in the broadband market. This is exactly the question, of course, to which the chairman referred in the 1776 speech when he pointed out the limited choice at high speeds for 75% of American homes. We continue to hear about the relationship between video and broadband deployment. As consumers increasingly use the internet to consume video, that drives greater demand for broadband. In other words, we're told that the demand for video and broadband go hand in glove. So, could a technology-neutral definition of MVPD boost broadband deployment by giving new and growing broadband networks the ability to increase demand, thus making their deployment profitable, realistic, perhaps speed its deployment? For example, the demand for broadband might increase if consumers knew they could use broadband connections to access MVPD services, regardless of whether the broadband network itself provided video programming, right? They could create the kinds of packages of which I spoke earlier broadband transmission, different forms of video programming on the devices of their choice. One more important question. Some might say that the video market is already so dynamic, lots of headlines this week, that the Commission should watch and wait. Look, I believe that the Commission, and I say this with all due respect, like everybody else in the room, can't see the future perfectly. And look, that always means that government agencies should proceed with care. But if a Commission rule can help unleash new business models that private capital is willing to fund, entrepreneurs are willing to bet on, and consumers are poised to select, shouldn't it consider doing so? Now, that's not the only example of incenting competition. Making available the infrastructure, the conduit, rights of ways, the poles necessary for build-outs must also be a priority, which is why today, as I said, the Commission adopted updated policies to facilitate the deployment of wireless infrastructure. Let me touch more briefly on two other themes. How does the Commission protect competition? An obvious way is through its merger review. The Communications Act instructs the Commission to review transactions involving licenses and authorizations and to determine whether such transactions would serve the public interest, convenience, and necessity. This FCC standard complements, while being different from and broader than the antitrust agency standard. We start off by analyzing competition much like the Department of Justice, much like the Federal Trade Commission. Like those antitrust agencies, the Commission considers a transaction's competitive effects and its potential to harm consumers. And the Commission staff bases its recommendations on market-related facts and economic data. This rigor ensures we make even-handed and well-reasoned decisions, or perhaps more accurately, that the Commission make those decisions aided by input of staff. So our starting point is the same, and as evidenced by the work this Commission did with the Department of Justice during reviews of NBC Comcast, AT&T T-Mobile, Verizon Spectrum Co., we work to move in harmony with antitrust agencies. Our view of competition in the wireless industry is a good example. Both the DOJ and the FCC leadership expressed their skepticism about a potential merger of Sprint and T-Mobile. The market conditions in the wireless sector led Chairman Wheeler to conclude that 4 national wireless providers are good for American consumers, and to state upon the announcement that the merger would not go forward, Sprint now has the opportunity to focus their efforts on robust competition. It seems that the chairman was right. Soon after publicly announcing their plans to move forward, Sprint unveiled subscriber plans that offer more data and incentives to lure customers. T-Mobile responded with a referral program of its own. Reports suggest that pricing strategies are pressuring Verizon and AT&T to lower their prices. So we've seen a lot of evidence that having 4 major players in the wireless industry results in more competition and lower prices for consumers, protecting competition. We've also sought to protect competition before and after the ongoing tech transitions. An important aspect of this network competition, and perhaps an aspect that hasn't gotten enough attention, is the future of copper networks. Now, of course, there's billions of dollars that have been and will continue to be invested in fiber networks, and that's a good thing, and the Commission supports it. But one should recognize how technology is advancing on copper as well. Technological advances are making copper-based DSL a powerful means of supplying broadband in some places for some purposes and at a fraction of the cost. The ubiquity of copper creates creative opportunities for businesses and other enterprise customers. These advances in copper technology can deliver high-speed broadband over those networks, especially over short distances, as might be the case with buildings or business buildings downtown or office parks. So in his speech, the 4th of his speeches given to Comtel, the chairman focused attention on 4 critical issues of improving last-mile competition, impacting last-mile competition. First, completion of our special access proceeding that I described earlier. Secondly, examining whether contractual provisions used by incumbents, such as lockup clauses, impede competition and facilities based on entry. Thirdly, the rules governing the retirement of copper networks. And fourth, the future of VoIP interconnection in an IP world. Let me come to the last of my three dimensions. The unique role of the Commission in expanding the contours of competition to include broader public interest considerations. As I've said, our standard is to ask whether actions are in the public interest. In the merger context, as I've already said, that includes an analysis of competition consistent with antitrust law and its modern-day emphasis on economic efficiencies. But the public interest standard also supports the pursuit of values that do not stand or fall on efficiency gains. The Commission considers, as it has said, the broader aims of the Communications Act. At a recent FCC roundtable, for example, Tim Wu emphasized that the FCC's public interest standard allows us to be sensitive to non-economic concerns such as free speech and innovation. On the point of innovation, he cited as examples the creation of Skype, Google Maps, social media in general, all of which resulted from innovations that stand for the overall improvement in consumers' everyday lives. And a focus on those broader goals is what makes the FCC's aperture encompass a broader view of innovation. Free expression ought to be noted here as well as a very, very important value. The Commission has quoted, not too long ago this year, from Justice Holmes' famous dissent in Abrams versus United States, where he wrote, quote, "The ultimate good desired is better reached by a free trade in ideas, that the best test of truth is the power of the thought to get itself adopted in the competition of the marketplace." The marketplace of ideas is an important metaphor because it highlights the importance of speech to listeners, the consumers, as it were, and not just to speakers, those who produce ideas. Now, although the Commission's authority is broad, the Commission remains disciplined in its focus on solid outcomes. While it can consider more than just antitrust economic principles, the Commission remains grounded in the facts and in marketplace realities. So that takes us to where we started on this talk, which is just one lawyer's interpretation of the chairman's mantra, and to illustrate where the Commission staff finds support for that mantra in the law and in ongoing issues. As I was getting ready to come over here, a colleague of mine suggested that the speech be entitled C-Cubed Protecting Opportunity. Good title, but I was reluctant to use a title whose abbreviation would be C3PO. Ambitious the Commission may be, but we don't wield lightsabers. And our goal is simply to provide the commissioners with the tools of competition. Even, I know there are a lot of economists in the room, so I say this with some trepidation, even dynamic markets don't move faster than the speed of light. But as a small green Jedi master might say, competition the future is, help you it will. Thank you very much.